If I can, just one thing before Dennis gets started, just a little preview. We divided the presentation with the beginning of really going over a lot of the legal provisions so that you had the framework within which to apply it when we get into the section of tips and practice area. So Dennis will be starting with that, and then I'll be coming in later. So I hope you enjoy.
Yes, and I'd like to thank all of you for being here today. It's always a pleasure to present on topics where there's absolutely no disagreement whatsoever. And so I'm quite certain that, there's some differing opinions in the room. And I was speaking to someone beforehand. I mean, our objective here is to be intellectually honest about all of this, have a conversation about it maybe at some point, and some questions and answers, and see if we can put some things on the plate, and see if we can give everybody a little bit better thinking about it as we move through and leave the room. So without going at it any more on that, the first part, as Thomasina told you, was starting at the highest level probably of how we're thinking about these concepts. And that would be starting with the rights of the parent, natural rights of the parent, before we get to the specifics of adoption intervention itself, the statute that allows for adoption intervention, the technical issues and requirements associated with that. So, at the beginning here in Florida, our most recent decision on a parent's rights, as we know, parents have a fundamental constitutional right to be a parent. Being a parent has not only those directive rights which they naturally possess, but also obligations which they naturally are expected to execute for the children that are in their care, custody, and control. And in viewing this particular fundamental right, at its highest level, a fundamental right is one which has its source in either the federal or state constitution or both. And when we look at the development of this fundamental right to parent, it goes actually back a long way. I believe it was in Ray Cam, which isn't in this PowerPoint slide here, but that really is, one of the first places that I recall reading about it, and which talks about it. I think we do have that in this a little bit later, and I think it was 1974, if I don't miss my guess. But the seminal case that we all deal with all the time, and we've all heard about, is Santosky versus Kraemer. And Santosky was the one where the U.S. Supreme Court really just came right out and said there's a fundamental liberty interest in the care, custody, and control of your children that doesn't evaporate because you haven't been a model parent. The reason why this is seminal to us in the abuse and neglect world is because it was literally dealing with the issues that we were facing. And so the courts had dealt with this issue long before. I mean, if we go back to law school, we can remember cases like Yoder versus Wisconsin and Prince versus Massachusetts. These things were dealing with the concepts of parents' rights and the state's right as parents' patriae and its obligation under state police power. But this is the seminal case that we refer to as a jumping-off point in our analysis, usually in dependency and abuse and neglect proceedings. Santosky really, in establishing the right, established it as a 14th Amendment right, which is due process, as we all know. And so in Santosky in particular, the court was testing what process was due when you're going to terminate parental rights. And so the argument there was on the state agency side that had the responsibility for the safety and welfare. They wanted termination standard to be a simple preponderance of the evidence standard, the one that we have in all of our dependency cases. And then the parents' argument on the other side was that no, it needs to be a heightened standard, and I believe they were asking for proof beyond a reasonable doubt. Well, in analyzing this right and making the determination, and really Santosky made it clear that this is due process, and they analyzed it under procedural due process. And in determining what process is due, they said, well, this parental right is not really the highest right because it's not a restraint on liberty. In other words, it's not like we're going to lock you up in jail, take away your actual liberty interest. but it's more than a property right. It's not as though we're going to go in and condemn a portion of your land for public use or something like that. And so, of course, then you could see that the Supreme Court was going to establish it somewhere in the middle, which is clear and convincing evidence. So that, in a nutshell, is really, the core of what Santosky is all about. So, what they were really saying is, when you're going to weaken the family bonds, when you're going to interfere with this fundamental right, you have to have fundamentally fair procedures. And then the seminal case, of course, and a lot of us know, when you're dealing with due process rights, Matthew versus Eldridge, three-pronged test for determining, it's balancing test to determine whether or not the procedure that you're looking at is constitutional. There it is, M. Ray Cam. Look at that. Although, this is a Florida case, and it was back in 1974, which is before Santosky. This established that parents' rights weren't absolute, and it was subject to the overriding welfare and best interest, which is where our police power under parents' patriae really springs from, and the state's inherent authority under Article 10 of the United States Constitution to exercise its police power as parents' patriae for those citizens, those vulnerable citizens that can't care for themselves. So let's take a look at due process a little bit closer before we move on. Procedural due process is a minimum level of process that's necessary in order for the proceedings for the thing to be constitutional. As we say, it's a floor, not a ceiling. And that's one of the ways that we have argument, because there's various ways to view what a floor is. So in some of our cases, in some of our arguments, I'm quite sure there are people in this room that would say the floor is a bit higher than what I would say the floor is. But nevertheless, that's what procedural due process entails. And so when you look at U.S. Supreme Court decisions in these matters, especially in the Lassiter case, and in Lassiter they were testing the bounds of due process in terms of whether or not we were going to give parents, whether parents were entitled to representation when you were in these proceedings, and in the Lassiter decision, which is a North Carolina case, I believe, they decided that in the balance, applying Matthews versus Eldridge, as they said we should do in Santosky versus Kraemer, they said that parents are entitled to representation by an attorney if their rights, their ultimate fundamental liberty interest is threatened, or they're threatened with incarceration by virtue of all of this. And so in Lassiter, the point to be made here is, I believe it was there that the U.S. Supreme Court said, this is the floor. States might have another idea and have a better idea than we have, but this is the floor of the United States Constitution in terms of due process on this particular issue. And of course, Florida established an across-the-board right to counsel in dependency matters, both at dependency stage as well as the termination of parental rights stage, based upon their understanding of that opinion. So, also, in analyzing due process is a fluid concept, and as we've seen now, you have to analyze each one of these items that you're going to ask whether or not the process is fair under the Constitution as they come. In other words, you have to analyze each one of them to determine whether or not there's a constitutional violation there. One of the recent ways that I can think that we've addressed this issue is when we were all debating the whether or not and to what degree we were going to have a procedure for ineffective assistance of counsel provided to parents. And so, we, as guardian ad litem folks, had one idea about that. The Department of Children and Families had an idea about that. Certainly, parents' attorneys had an idea about that. And so, in that debate, in that process, a lot of our conversations were centered around what processes do. And so, we did a pretty good dive into the folks that wanted Sixth Amendment procedures that are used in criminal matters, and in the balance in Etheridge, these are dependency matters, so that it's not quite the right at risk is not quite that, and we were arguing it's this, and so the Supreme Court came up with the procedure you have. But not to belabor the point, but that's how it comes up on a case-by-case basis with the work that we do and the work that you are actually doing in the courtrooms. So as we said, due process is flexible, and it's not so rigid as to do away with informality and flexibility. Again, I think there's a lot of different views of this as well. I mean, coming from a guardian ad litem point of view, my point of view is that in dependency court, it is an exercise of state police power as parents patriae. The court itself is in loco parentis in the shoes of the parent. Therefore, we would argue for usually maximum discretion that a judge has in the courtroom, because dependency judges have independent duties and obligations regarding the child's safety and welfare, in separate and apart from children and families, separate and apart from our representation of children, which is why we're an information provider to the court in that regard, in addition to our other duties as well. So the court has some flexibility. I mean, for example, in your judicial review hearings, and 39701 really suspends the rules of evidence for those hearings and allows the court to ask questions, to conduct its own inquiry, and so forth. And so in that sense, dependency court, in our view, is more of a court of chancery than it is a pure court of law all of the time. And I think that decision, I believe that decision is borne out in cases such as In the Interest of JS and Brown versus Ripley. Those are seminal cases here in Florida which discuss these matters. So that's our view. There's other views of it, certainly as well. And again, due process and all of these being fluid concepts subject to individual independent review from time to time. So looking at these concepts in terms of private adoption, intervention, and dependency proceedings, the legislative guidance which we've seen recently is when Senate Bill 590, which revised the adoption intervention statutes, the legislative staff recognize the provisional role of the court as being in loco parentis, and recognize that while they have constitutional rights, those rights are impinged and they cannot unilaterally make decisions when there has been a finding of unfitness. And I think that, just to be honest with you, I think, and we'll talk some more about this in a minute, but I think the way these arguments are developing in terms of these adoption intervention cases that we all feel so passionately about, I think, one of the things that this statute has done, I believe it has resulted in courts having more discretion, or at least exercising more discretion than we saw across the board before. And so out of that exercise of discretion, I know that our operation has appealed many of these cases that we felt that the court might have departed from the essential requirements of law and there would be irreparable harm, that sort of thing. And we have lost all of them. And I believe that the other side of this has appealed several of these decisions, making the same arguments on the other side. And I believe you have lost all of them. I mean, I don't think either one of us is getting the better of this business, is what I'm saying. And so the courts, the review courts, have been very reluctant to overturn a circuit court's decision based upon discretion, is what I personally believe about that. And so our arguments have really kind of centered on, some of us believing that the parents have an absolute constitutional right in using that number 8 out of the factors that have to be considered for best interest, and saying there's a constitutional right. And then us on the other side arguing, well, no, that's not a constitutional right, that's a statutory right. And so the court's free to consider it as much as they want within the context of the dependency case. I think that's just honestly the way these arguments that I've been seeing. And Tom might have a different view, but I think that's honestly the way these have been going. So, from our view, adoption is unknown at common law and exists only by virtue of statute. That came out of the GS case. That's what we've argued. And the third district has pretty much followed that by saying that parents have a fundamental right to raise their children. But 63082 really provides the parent with a statutory right, and it's not an absolute right, which gives, in our view, gives the court discretion. That was the EQ case in 2017. Recently, there was another case that came out of the 5th District, which seemed to follow that reasoning, and that court, the appellate there was arguing that he was denied the right to engage in a private adoption because it was a constitutional right. 5th District said that that's a statutory right, and it's secondary to the court's duty and dependency proceedings to do what is ever in the best interest of the child. And so the EQ court and this JG court are really saying that the parents' wishes are really one factor, to be determined in the overall best interest scheme.
If I can interject there as well, I think that it's important to kind of pause on that for just a second because of what we're presenting, and that is representing the child in adoption intervention proceedings, and keeping in mind as you're representing the child in those proceedings, best interest of the child is the standard, and is what is the standard both in 39 and 63 proceedings for them. So that's one case. It's very new. It doesn't even have a full site yet that particularly resonates in the context of what we're doing here.
Okay. And so, in just doing our tour of review courts on this issue, the 2nd District, there's no real decision on this issue yet. And as I say, neither one of us are getting the better of this business. We are all being PCA'd. And I have to tell you, in just our cases with one another, that's a new thing for us on the Guardians. I mean, we get PCAs. We're hopeful to usually get PCAs on the other side in our fights. But per curiam affirmed, it's without an opinion. Per curiam affirmed. And essentially it means that they're going to affirm the lower court's decision without an opinion. And so in the 2nd District, they have issued no opinions on this subject yet. Most of them are PCAs. And there's no clear decision from the 4th District on it yet, but the WK case did reference constitutional rights. We filed an appeal on that, or we asked for clarification, I believe, at the end of that case. And while they denied our motion for clarification, they went back in and modified their opinion to delete the references to the parent's constitutional right. Is that correct, Thomasina? That is. Okay. And so then you have this YG case that is coming out of the 1st District. And this one is a little interesting in two ways. In this particular case, they reference the parent's constitutional right to care, custody, and control. Really, this straight-up Santosky versus Kraemer, fundamental liberty interest in care, custody, and control, and talked about not comparing placements, the court in DCF not comparing placement decisions that the parent would otherwise choose. And so we at the Guardian Office were a little confused about that. So we filed a motion for rehearing and clarification, and we argued that it was unclear whether or not the court was making a decision that there is a fundamental constitutional right to adoption or to select the placement for adoption in these cases. And that's an issue, obviously, that's important to all of us. So we needed clarification on that to see what our options would be if that was the decision of the court. The interesting thing here is that the parent's attorney in this particular case didn't really take issue with the fact that it was not that adoption was or this sort of thing was a constitutional right of the parent, because the interesting thing that we read is the parent said that nothing in the opinion can be interpreted as a recognition of parent has a constitutional right to direct adoptive placement. You know, and by the way, we're losing these rehearing opinions, right? I mean, or these are this.
Well, I know they said they denied the rehearing
Yeah.
WK, but when they changed the opinion, I consider that a win.
But anyway.
Depends on how you define win.
Right. Okay. And then the parent went on further to suggest that the language that the court cited regarding the care, custody, and the general language of the general right of parents, the broad fundamental right, supports the parent's statutory right pursuant to 63082, which we thought was a novel argument and a bit interesting. So the question then, okay, the motion was denied. Sorry about that. But the question remains, what does the first district think about the constitutional right? Does that agree? Do they agree with the third district and with the fifth district? Yes?
It was just a couple months ago. No, sorry, 2018. YG was 2018, JG was new.
Yeah,
I apologize.
JG is new. So the fifth district case is very new, and the YG case a year old. Okay. So important things to remember about YG is it didn't involve a decision on the merits of the motion to change custody, and the delay in filing the intervention motion was not due to dilatory delay by the interveners. Those were the reasons what the court gave on the appeal for the judges, to overturn the judge's decision not to hear it at all, and that was what was overturned in YG. So, yeah, that's correct. That's correct. The motion itself was never heard. They were denied the right to assert and intervene summarily, is I believe how the district court would have viewed that, which is, a bit different than hearing it and dealing with the judge's discretionary decision in our view. But in dealing with that, this other issue is raised. So there's a lot of questions that are unresolved regarding that. And our belief is that perhaps we are moving into more of a substantive due process argument than a strict procedural due process argument, which would put that in a zone of a case such as Troxel versus Granville, and back to State versus JP here in Florida, North Florida Women's Health, so forth in those opinions. And we won't dive into that right now. And I don't know that we would resolve those issues right now, even though the ensuing melee would be fun for all of us. But in our view, this is sort of where we're at in terms of the bigger picture. So with that in mind, I'd go ahead and turn it over to Thomasina and let her talk more about the specifics of adoption intervention. Thank you.
That's a fundamental question.
Sure.
My presumption is that these whole processes are, while parents' rights are still intact, there has not been a termination of the criminal rights, because that changes that whole dynamics. Is that my assumption correct?
Yes.
Yeah, that's correct. Okay.
That's a pretty deep dive into constitutional law, huh? I talk to people about what we do in dependency proceedings, and they're frequently amazed that we do constitutional law at all, and I think they would really be overwhelmed if they saw how deep of a dive we actually end up doing into constitutional law, because there's some real serious issues here. So I want to... did we go... Sorry, the slides are not caught up. Oh, that's why. Ah, this is not my remote, and I'm holding it backwards. I'm sorry. All right, adoption, intervention, purpose, and intent. this is really something that I think we should also consider very carefully as we work through the adoption intervention issues, because there was a clear legislative intent. And that was the fact that there's a compelling interest in providing stable and permanent homes for adoptive children in a prompt manner, and preventing the disruption of adoptive placements, and in holding parents accountable for meeting the needs of children. The legislative intent in doing this was to find homes for children and find them more quickly. It's the intent of the legislature to provide for cooperation between private adoption entities and the Department of Children and Families in matters relating to permanent placement options for children in the care of the department whose birth parents wish to participate in a private adoption plan with a qualified family. I will point out one thing with the legislative intent, and I do believe the legislative intent predates some of the changes to the statute, particularly the intervention in 63082. One of the things that I find irreconcilable within the statute now, and there are, I believe, several internal inconsistencies, is that the legislative intent references an adoption plan, but if you do look at the definition of adoption plan in the statute, you can only have an adoption plan if your child is not in the custody of the department. So the definition of adoption plan does not meet this statement. What I think we all know really is that you're participating in a motion for a change of placement and a placement concept, not an adoption plan itself. It might be a subtle difference, but I think it really rears its head when you interpret case law in this area, because there are cases on adoption plans and it may not be as easily applied as one might think, given the fact of the internal tension. And I would urge everybody to take a look at the definitions. There's a lot there that would inform you, I think, and you might be surprised at. Intervention allows a parent whose child has been removed by the state to retain the right to execute a consent to adoption, provided their parental rights are still intact. What the adoption intervention statute does is to create a public-private partnership envisioned by the legislature relating to private adoption plans, which can increase permanency via adoptions and decrease the financial burdens of our child welfare system. So it's meant to benefit everybody, most particularly the child, by speeding things up. Prior to its revision in 2016, Section 63082 was interpreted as requiring the court to consider the appropriateness of the birth parent's choice. Anybody who does adoption intervention probably knows this infamous, I think, footnote 4 of SNW, and I say infamous just because there's a lot of disagreement on what it means and how to apply it, and as we'll see what it means now. But in that case, the court did say this consideration shall not include a comparison between the attributes of the parent and those of any persons providing a present or potential placement for the child. Viewed in this light, the best interest analysis requires a determination that the birth parent's choice of prospective adoptive parents is appropriate and protects the well-being of the child, not that it is the best choice as evaluated by the court or the department in light of other alternatives. The reasoning within SNW that was given for that was a reference to the parent's fundamental interest in being a parent. And the constitutional reference has been cited. I worked on a brief yesterday where it was cited to show that there is still a constitutional right to adoption intervention. I think from my point of view, GS shut that down when it was first issued from the Florida Supreme Court, in that it says adoption is purely a creature of statute. I believe the two district courts that have addressed it directly, the third and the fifth, have it right. And I think the fourth kind of signaled they think it's not a constitutional right by substituting that opinion. So whether the second district's reasoning there is still viable is really questionable, just given those cases. But in addition to that, in 2016, the statute was amended to revise the standard of review used by the court when making a determination of a change of placement of a child from the appropriateness of the placement to the best interests of the child. That was the legislative intent. And if you have I'm going to go back for a second, if you have an opinion like SNW does that specifically references the legislative intent in reasoning how it should make the determination before it, if that legislative intent changes and the statute changes, I think that case has to go by the wayside. It's been applied that way in many other instances of statutory interpretation, and I think that's something that really needs to be considered here. In the committee, it was made clear that the best interest determination is the best interest of the child is the same way as any other child in dependency system. There's the committee reference note, and it specifically changed the legislative intent and addressed the placement as S&W stated. And so, statutory law. I'm going to go through some of the rest of determining the sufficiency and going into some of the criteria. With the change in the statute, they also made it clear that a parent has to be provided written notice of the parent's right to participate in a private adoption plan, including written notice of the required best interest factors at the arraignment hearing, in the order that approves the case plan, and in the order that changes a permanency goal to adoption. All right, so let's decide. How do you determine the sufficiency of a motion to intervene? It's a Texas two-step. It's a two-step process. First, you have to determine whether or not the person seeking to intervene or the adoption entity seeking to intervene gets party status. If they do get party status, then you consider whether the motion to modify the placement should be granted. If an adoption entity files a motion to intervene in the dependency case in accordance with this chapter, the dependency court shall promptly grant a hearing to determine if the adoption entity has filed the required documents to be permitted to intervene and whether a change of placement of the child is appropriate. I reference entity mostly throughout here because in most circumstances you are going to have an adoption entity. However, if you have a relative that is the person that is seeking to have the prospective adoptive placement, you don't have to use an adoption entity. In all other instances, it is required, and that's why we address really that instance, because it is far and away the most frequent. All right, so to determine party status, you have to look, is a valid consent from the parent attached? The statute provides the requirements, the notice requirements, and you should analyze it and make sure that all of the statutory requirements are met. Sometimes they're not. And then you have to look and see, is a preliminary home study filed? If the home study is deemed sufficient unless the court has concerns regarding the home study provider's qualifications or adequacy of the home study in determining the child's best interest, the home study must be maintained as confidential in the file. And then, was there evidence of the suitability of placement provided? With the home study, you're going to see in 63084 there are statutory requirements for the home study, but it is not an exhaustive list. It has some more that catch-all generic language that the court can look at something that is also specific to these particular children. The one case I think I remember the most where this was at issue was a case where the prospective adoptive parents had tried to be adoptive parents through the department and had not succeeded, and then in a different case had, I think it's a different case, had done the adoption intervention. They had already expressed to the court that they did not want a special needs child. The child that was going to be placed with them was going to be a special needs child. So the court said that the regular home study was not sufficient for them and added additional factors that they wanted addressed to see whether or not this change should be considered and if their home could in fact accommodate a special needs child, because that was one of the factors that the prospective adoptive parents had listed as a reason why they did not want to have the special needs child to begin with. So the home study that's in 084, those factors are not the only ones that can be considered. And if you have something particular to the child, then you should make sure that the court looks at those factors and considers them as well. In modifying the placement, the court looks at whether or not the change of placement or the adoption is in the best interest of the child. The court has to consider and weigh all relevant factors to determine if a change of placement and adoption is in the child's best interest. Required best interest factors. There's 8 statutory factors. That's since the revision. Prior to that, there were 4, so they doubled them. It's the permanency offered, the bond between the child and the current caregiver, the stability of the current potential adoptive home and maintaining continuity, maintaining sibling relationships, and in that you can use the definition of sibling. It's in Chapter 39. The child's preferences and wishes, if it's appropriate to ask them if they're age appropriate and they're developmentally can have those questions, yes.
I'm not sure everyone understands the allusion you made to the statutory definition of siblings. You might want to elaborate on how it's
The statutory, thank you. Statutory definition of siblings in Chapter 39 includes children that reside together, not simply blood relations. They've expanded it to have a more inclusive definition of sibling. And it's, since the adoption intervention is into 39, there's a case that says specifically you apply 39 and juvenile rules, and so you can apply that definition. I think it's funny, just as a side anecdote, someone today expressed to me they did not like that case. They thought it was a completely wrong decision, and the case name is BS. So that particular case may be aptly named for him. What is the best interest of the child is considered, and the parent's right to determine an appropriate placement. Yes?
Question. So these are for modifying placement only. Is it the GAO's position that if you're not trying to change placement and that your motion to intervene does not want to change placement but keep the child there, that you would still need to go through this 8 factors?
I want to make sure I understand your factual scenario, so if we could just expand on that just a little bit before I do that. So
Are in foster care?
they're in foster care.
Seeking to move the child, the foster parents are intervening to adopt.
Do they have a consent?
Yes. In the home study.
That presents a difficult issue given the Florida Administrative Code. I think that I can see the logic of saying, and this has come up not that far internally, of saying we don't have to analyze these factors, but since the department with a motion to intervene, if it is granted, will change their procedure and how they're handling the case afterwards, I would suggest it would be appropriate to go ahead and do the statutory analysis and go ahead and get the motion granted. Otherwise, I think you will create a situation where you have a real legal limbo as far as what the department position would be, what services they would do, what other steps they would take. So I'm not sure that's clear on whether you have to. As a best practice tip, I would suggest it would be cleaner that way and easier for everybody involved.
Can I interrupt?
Ah.
I don't have anything to say. I just want to make sure I could still interrupt. No.
You've never asked before.
Right, it's true. But anyway, my 2 cents on this issue is this. I mean, when you look at these factors, my understanding is this is what the legislature, in the judge's discretion, what it clearly says is anything that you feel is bearing on best interest, judge, you also should consider. But you must consider these. And so my 2 cents on that would be, the child's best interest is always in play. Whether you're going to change the placement, whether you're going to leave them there for adoption or whatever, it's always in play. The question to me would boil down to, judge, do you have to consider these? I mean, to me, that's how I would view it. If they're applicable, you got to consider them anyway. That'd be the only thing. That's my 2 cents.
Yes.
Do you guys have any thoughts on whether the court is required to weigh each factor equally or whether they have the discretion to weigh each as they see fit? Because I've seen it done both ways.
I believe case law supports that they are simple factors that the court weighs and that no one outweighs the other. So I believe that, again, this statute was revised in a way to determine the best interest of the child and what's best for the child and to give the court more discretion. It would be contrary to legislative intent, in my opinion, to limit the court and say you have to consider each one equally if the entire intent of the statute is to give judges more discretion. So no, I think the court, it would be like manifest best interest. I think that it's really just how the court weighs the factors. And for the last one of these, the parent's right to determine an appropriate placement.
I'm always puzzled by the factor, what is best for the child as a factor in the child's best interest. Do you have any thoughts on why that's?
I think that what that was intended to do would be to give you that catch-all and expand the court's ability to consider something other than the other seven factors, and say maybe there's other things such as the scenario I gave where the parents had said that they did not want to have a special needs child, but this was a special needs child that would require a lot of care, and the court considered that. So I think it's really intended as a kind of catch-all and give the court more discretion. And then again, just to tie off that last factor, I want to draw your attention to that one because I believe that the consent itself is very important for how this factor is applied. There are different types of consents. Consents in Florida law do not have to be specific to an individual. They can be given to the adoption entity as a whole, and when they are given to the adoption entity, and then the adoption entity finds a parent and chooses that parent, I don't believe that factor is in play because the parent has not chosen the placement. The adoption entity has. So when you have a consent, you really have to look at it and see, is it conditional or is it just to the entity? And if it's just to the entity, then I would argue, and I believe you could support very well, the parent hasn't chosen the placement, the entity did. And the entity is not entitled to be given the same deference as the parent, whether you believe S&W or not, because they don't have the same constitutional right. It's not transferable. All right, again, I referenced the Florida Administrative Code earlier. This is the code provision that the department uses. It's chock full of information on how they apply the best interest analysis. It has additional factors that they list other than the 8 that maybe is part of how they view the child's best interest. Kind of gives you an insight there. It tells you their process and procedure for handling a case if a motion to intervene is granted. It also gives you some insight into documents and what files, et cetera, that they have that they need to provide to the intervener in order to allow the intervener to satisfy their statutory duties. So another good piece of information there to read. The court must enter a written order within 15 days of the hearing. We will upload a bench card. It wasn't uploaded yet. I apologize for that. You will see there is a time frame. It's pretty strict, pretty fast in the rule. You have 30 days to have the hearing, and then the order must be entered within 15 days of the end of the hearing. And to grant the motion, the court has to determine the entity filed the required documents to be permitted to intervene, that the prospective parents are properly qualified to adopt the child, and the change of placement and adoption is in the child's best interest. And I want to take a step back with that second factor. The language regarding whether the prospective parents are properly qualified to adopt the child, you're going to see if you look at the adoption intervention statute on when the who can intervene and when the consents become valid, binding, and enforceable. And it's interesting because there's a distinction there, and it says if they're filed by the adoption entity or a qualified adoptive parent. The only other reference I can find in the statute to qualified adoptive parent is that one. And it says that a qualified adoptive parent is one that meets those 8 factors. It's referenced in subsection D. So I believe that the statute can be broken down to say, if you have an adoption entity, because they're licensed and they've already been reviewed by the state and they've had to go through that whole process, or if the court determines based on these 8 factors that the person is a qualified adoptive parent, then the consent is going to become valid, binding, and enforceable. There's nothing on that out there. That's a personal interpretation based on everything I looked at over a very long time in December. I spent a good bit of time. I read every single provision of the statute. I read all the cases I could on it, and that's an interpretation based on the fact that that language has to mean something, and that's the closest I can find to what it would mean. The court may establish reasonable requirements for transfer of custody transition, and I would suggest that most of the time, if they don't establish requirements, they would be pretty irresponsible given the circumstances. After the transfer, the adoption entity shall every 90 days inform the court of the status of the adoption hearing until finalization, and every month until finalization provide supervision reports to DCF. All right, so that's kind of how the statute. So what we have now is we have the overview with the due process rights of the parents and the extent of that. You've seen what the statute requires, what its provisions are. We wanted to talk a little bit about how it goes into effect in practical terms, what you're seeing every day. So a few practical tips and practice tips and training issues. There are a lot. I could not complete all of them if I tried, I don't think, in the amount of time we have here. We will do questions and answers at the end, and I'm willing to stay a little bit after and answer some additional questions if anyone has them, if we run out of time. But these are the ones that we have been seeing more frequently, or which were conveyed to us by various entities as being, the ones that they really find most important. Starting at the beginning, shelter stage. In order to adjudicate a child dependent, a trial court must find that the child has been abused, abandoned, or neglected, or at risk of imminent abuse, abandonment, or neglect. The execution of an irrevocable consent for adoption may foreclose that finding. If you have a consent and you have the hearing and determine that this is a qualified prospective adoptive parent and a safe home, and the judge moves them prior to the adjudication hearing, then you may have the ability to say this should now be dismissed and be dropped before you move on. That would be the fastest way to get this resolved, and I think given the desire for the proceedings to be resolved quickly, a good one, if you could do that. This shelter proceeding should be dismissed if the parent has signed a consent for adoption and selected an appropriate placement for the child. Party status. What is the status of the individuals? Florida statutes provide upon execution of the consent of the parent, the adoption entity shall be permitted to intervene in the dependency case as a party in interest and must provide the court that acquired jurisdiction over the minor pursuant to the shelter order or dependency petition filed by the department, a copy of the preliminary home study of the prospective adoptive parents, and any other evidence of the suitability of the placement. So in order to file the motion and to be able to come in and intervene, you have to meet those two requirements, both that you have the consents and also that you have a home study. I was asked, does the home study have to be positive? And the answer is yes. It's in 63084. And if it's not a positive home study, it does not qualify as a sufficient home study under the adoption intervention statute. This is a mandatory directive. If the consents meet the statute's technical requirements, that's possessive, not plural, I'll fix that. And all other required documents are filed. There should be a prompt threshold order or an agreement that the adoption entity has a party interest status. These hearings kind of play out very individualized throughout the state, and there are entities that want that initial hearing and determination, and there are others that push to have everything done in one day. If you are not pushing to have it all done in one day, for whatever reason, and you bifurcate the proceeding into the first step, then yes, it's mandatory if they meet the requirements of, and that's the required documents would be those. The consent is valid, it meets all the bells and whistles, the home study is positive and is satisfactory to the court, then yes, you should be able to get party in interest status. If you get the party in interest status as an adoption entity, you can conduct discovery, take depositions, schedule hearings, and have access to relevant portions of the department's and GAL's file as it relates to the child at issue. The adoption entity is bound to the same confidentiality protections as the rest of the parties. I want to emphasize relevant here. If you have a case with multiple children, and the consent is for one, you don't get everything about all the children. You get what's pertinent to what you need for the consent for that one child. The relevant portion language is very important. Access to DCF and the child's files. Statutory provision has disclosures required, and what the adoption entity has to disclose to the adopted parent. If you ever do get a chance to read the administrative code, you're going to see some overlap here necessarily. And this really tells you, I also believe should inform the scope of discovery in that if the adoption entity has a duty to provide certain information, then they should be able to discover it. And so it should also inform the parties of the scope there. And that is that the adoption entity responsible for selecting prospective adoptive parents for a born or unborn child whose parents are seeking to place the child for adoption or whose rights were terminated pursuant to Chapter 39, the adoption entity must provide the prospective adoptive parents with information concerning the background of the child to the extent such information is disclosed to the adoption entity by the parent, legal custodian, or the department. This subsection applies only if the adoption entity identifies the prospective adoptive parents and supervises the placement of the child in the prospective adoptive parent's home. Remember earlier I was mentioning conditional consents where the parent selects the actual placement? This language would suggest that the adoption entity is not bound to provide the information in those circumstances.
What about cases where after the intervention is filed, the current foster parents then seek to intervene, they file a TPR they then seek party status. Have you addressed that issue? Do those foster parents then get access to the file and these confidential information?
I'm going to repeat that back to you, make sure I understand what you're asking, because there are a few facts there. All right, you have a foster family that has a consent to adopt and has moved to intervene?
No, their adoption intervention just goes forward.
Gotcha.
The current placement is a foster parent who wants to adopt, so they oppose.
The intervention.
So they file a TPR petition, they ask for party status and join in on all this melee. So we've had questions about whether foster parents can even file a TPR petition and whether they can get party status, and if they do, can they get access to all this information?
Okay. No, that's fine. Let's start at the beginning. All right. Can the foster parent file a TPR petition? A TPR petition can be filed by anybody who has information regarding the grounds for the TPR. So, whether or not the foster family can file a TPR petition, I believe will depend on whether or not they have actual information which they can use to support and prove the TPR petition. There's no provision for joinder of the department's petition. That's come up recently as well. The rules allow for some joinder for people who are already parties, and in that instance, they are not. So they can't just join. But if they can meet that standard, they can file a petition. It's got to be filed in the same way as any others, verified, etc. Then there's the question of, do you have them file it within the proceeding that's in front of you, or does it have to be filed separately? There's no statutory provision that says it can be filed in the proceeding in front of you and in that same case. So there's an argument, no. There's no case law on whether they can or can't in the same case, but there's that argument that it says you can file it, but you don't have to come into mine. And there might be reasons why they shouldn't. They may also file it and seek to have the two cases consolidated. But it's very relevant to determine whether it should be filed within the same proceeding, I believe, based on the number of children. Are they filing a TPR as to all of them or not? Is it proper for them to come in to a case where there's 6 children there want to file as to 1, and then have all discovery for every child there? And I think that somewhat subverts the legislative intent. The legislature was very clear and very careful in structuring party status and participant status within the Chapter 39, and in general, they don't have it. Florida case law supports that. OFFER, which is from the Florida Supreme Court, it's the Organization of Foster Family Reform, Equity and Reform, I believe it is, says no, as a general rule, foster parents don't have a standing issue. So you're really altering the intent of 39 if they come in and just get access to everything. So I do think you have to look at whether or not they have a basis to file it, and then whether it's proper to have it within that existing 39 proceeding. Let's just assume it does. If they file it within 39, the court says yes, it should be within the same proceeding or the case is consolidated, they would get discovery. They would not get discovery pursuant to this provision because they're not interveners at that point. So 63 wouldn't apply to them at all. They would do it pursuant to whatever rights they would have as a party under Chapter 39. And that's how that would work. As I said, I don't think that, there's a lot of those issues that are unresolved. But the statute does give pretty good guidance on how they want it to be done. And I have had a few writs of certiorari recently, or I should say my team has had. They're getting well-versed in adoption intervention. And so we've really looked at these issues and did it recently with one where there was an intent simply to do a notice of adoption. So within the last couple of weeks, we've really done a deep dive into what are the statutory provisions, what are the rules, what's the intent. And we do believe, based on our best reasoning, that that's the right rule and the right result for those cases. All right, so access continued. The information to be disclosed includes record documenting all incidents that required the department to provide services to the child, including all orders of adjudication of dependency or termination of parental rights issued pursuant to Chapter 39, any case plans drafted to address the child's needs, all protective services investigations identifying the child as a victim, and all guardian ad litem reports filed with the court concerning the child. So looking at this again, this should inform your discovery and what is the extent or what is appropriate. Because again, if you have an adoption entity with requirements for disclosures, then yes, they should be given those documents. So GAL program, if you're an adoption entity, you have the motion approved and you've been allowed to intervene, we'll give you our reports. We will send them to you. Past that, I don't know that it's come up. If it's relevant to the child and relevant to the determination at issue, then we will work and get all of the information. Confidentiality. 39202 provides the confidentiality. Remember, the BS case said you apply these rules, even though its basis is Chapter 63. So once the information is provided to the entity, it remains confidential. They have the same confidentiality requirements as any other party, and that's specifically provided for within the statute, which provides at the end that except as provided in subsection 4, access to records shall be granted only to the following persons, officials, and agencies. And within that list includes an adoption entity acting on behalf of pre-adoptive or adoptive parents. So that it's specifically contemplated that 39202 and the provisions would apply. Venue and jurisdiction. Pendency of the dependency proceeding did not prohibit a grandmother from filing a separate adoption proceeding, and that's from the In Re KAG case from the 5th District in 2014. However, the pendency of the dependency proceeding does not prohibit the adoption entity from filing a separate termination of parental rights proceeding, but the petition to intervene must be filed in the dependency action, and the dependency court has exclusive jurisdiction over the child unless it relinquishes jurisdiction so the adoption entity can file a TPR elsewhere. Yes?
So if that has not been relinquished to the adoption entity, there's supposed to
I'm sorry, I can't hear you.
Sorry, if
That's
they're
okay.
not relinquishing jurisdiction to the adoption entity, then they're supposed to be filing the TPR petition and the petition for adoption within the Chapter 39 case, or can they file that elsewhere?
Typically, from what I've seen, once you get to the state portion or state of the case that the adoption entity's motion to intervene and for change of placement has been granted, what's provided for in the administrative code is that DCF will close their case and put reason transferred to another agency. And so then you are going to be going over and moving to another 63 proceeding. And and how that works varies a little bit differently in different circuits, especially with unified courts.
And I guess my question with that was, we have that with adoption, or intervention has been granted, the motion to transfer has been granted, the child hasn't been moved, it's out of state. And I think after reading a portion of, I don't remember if it was the code or the statute, DCF is supposed to stay on the case until the child leaves to the adoption placement. So they're still there. So I guess my question is, if DCF is still involved, we're still involved. Once they file all that, it does not have to be within our current open case.
I think it does. I think you still have, that same court would still have jurisdiction over that child ultimately. There is a case on which court has jurisdiction between family law, divorce proceeding, and dependency, and in that case they said the dependency court trumped once that jurisdiction had attached. I think in this instance, just because of where you are and procedurally, you would stay within the 39. Sure. The adoption okay, what happens if the motion for change of placement is denied? This happens a lot. As Dennis said, how the judge determines it is not been overturned either way. So when they are denied, it's needed to know what is the proceeding. The adoption intervention statute provides the adoption consent is valid, binding, and enforceable by the court. If the consent was executed in favor of the adoption entity is responsible for the child. That's from CG versus Gal from the 4th DCA in 2006, and it says, once an adoption entity accepts a consent for adoption, it does not have the right to reject the surrender. The consent bound the adoption entity to accept responsibility for placement of the child. So that adoption entity is still bound to that child, bound to find a good placement for the child. if it's executed in favor of the adoption entity, and this goes back to, was it a conditional consent where it's naming certain individuals, and you see those sometimes. I want the child to be adopted by my aunt and uncle, Mary and Bill. Then this would not apply because that is not to the adoption entity. But if it's, I'm executing the consent in favor of a single entity, this applies. Right, so what's the solution for that? What do you do when you have a case and the motion to change placement's been denied? There's several things you can do. First of all, you should proceed with TPR if appropriate. Case should not stop while you see if they find somebody else. They may not. Time is the right of the child. Chapter 39 is very clear on that. Chapter 39 applies. If it's appropriate, proceed with TPR. You can ask, or the adoption entity can also look to have an alternate placement that's determined to be in the best interest. They're not bound from trying to find another placement for the child. And it was recently argued in a brief by an adoption entity that, I can't just say, new person without, and use the other person's home study. I agree with that, you can't. But you can get a new home study, you can submit that home study to the court, you can have the best interest hearing for the new potential adopted placement, and if it's appropriate, the court will grant the motion. And another solution would be to have the adoption entity assign its rights under the consent to the department. If the adoption entity, and there are some that don't, does not want to have that responsibility, because there are a lot of responsibility, including care and maintenance under the statute, then, which I don't think is really ever enforced, then they could surrender and say, here, I want to assign this to you.